Ladies and gentlemen, faculty, students, distinguished guests, good morning and welcome to Lexposium 2025, the Cradle for Future Jurists, presented by SRM School of Law. We now welcome to the stage Hon'ble Justice Sanjay Kharol, Judge of the Supreme Court of India, to deliver a keynote address on the evolution of law to accommodate evolving socio-economic realities in contemporary India.
Friends, I have to share certain thoughts with you. We gather at a moment of intense change. The questions of our age no longer sit comfortably within the old doctrinal boxes. They lie at the intersection of law, technology, constitutional values, and ethics. But above all, they raise a deeper question. What kind of republic are we becoming? And what principles must we defend to preserve the idea of India? The Constitution, in this sense, is not only a legal document, but also an ethical statement, a compact between the state and the people. Law that remains distant or overly theoretical does not serve the person standing outside a courtroom seeking redress. So we have to reach out to those who do not have access to justice. Friends and faculty, universities too are crucibles of constitutional values. Our law schools must impart technical knowledge but also mature moral imagination. Above all, our courts and commissions must act not only as adjudicators of dispute, but also as custodians of constitutional conscience. The task before legal institutions is immense. Case backlogs demand robust case management. Digitalization of filings and hearings can improve access and transparency. ADR mechanism can reduce burdens and empower communities to resolve conflicts on their own terms. I'm saying this in particular because you as law students can help us reduce the backlog. And we need a spirit of service by institutionalizing legal aid, pro bono work, and community outreach so that the justice becomes routine and not the exception. Let us leave this hall committed to ensuring that legal change advances human dignity and public good, as also public welfare. We can foster regulatory wisdom, broaden access to justice, and embrace innovation with suitable safeguards. We shall have served our Constitution well. Thank you. Jai Hind.
My question to you, sir, is what do we mean when we say realizing the true spirit of the preamble?
Preamble to the Constitution has adorned my office table from the day I became a judge. And I found that whenever I'm in difficulty in interpreting any provision, especially in constitutional matters, I read the preamble, reread it, and I find my answers there. Mm-hmm. Because the whole spirit of the Constitution is embodied in the preamble to the Constitution. We are becoming a country of people who are not willing to listen to the other point of view. We are becoming a country which is intolerant, not only religion, I'm not talking about intolerant of another point of view.
What's the biggest challenge before, let's say, a judge in ensuring the right to dissent is preserved, but at the same time not abused?
Absolutely. That is the balance which has to be struck. See, right of dissent, there can be no quarrel with that. Everybody has a right to dissent. But that dissent must be also expressed in constitutional ways. It also must be expressed non-violently. It also must be expressed, but merely because you criticize the powers that be, and whoever be it power. You see, irrespective of the political connotations, whoever is in power tries to protect their power. And nobody likes criticism. And if you don't like criticism, and being just following anybody and not criticizing is an anathema in democracy.
Thanks very much there, Justice Gupta,
Thank you
for
so much,
taking time
Raghav.
out to
Thank you.
speak to us.
I first asked all the students who are present that since morning you are listening to the word justice. Justice has so many phrases. Justice is the word which you find in our preamble. And we talk about justice in our preamble. It says about social, it says about political, it says about economical. Rest you will not find this justice in the Constitution. To my understanding of our Constitution, and particularly the preamble, which is the heart and soul of this living document, when we talk about social justice, it's a equality amongst the society. All must be equal. When we talk about economical justice, a disparity of economy among the citizens must have to be rescheduled and brought at par. When we talk about political justice, this is only for the purpose to see that every citizen has a right to cast vote. And when we come to the term labor justice, there was a time when there was almost 20 plus labor laws. Whether it's a Minimum Wages Act, Payment of Wages Act, there was an industrial dispute, which is a heart of the whole industrial law in controlling the labor laws. Good of this government, they have codified the labor laws. They have summarized them. They have put those labor laws into order and call a labor regulation code. And when we talk about labor justice, it only refers to ensuring fairness, dignity, and protection for workers. And that will be possible only when there is a fair wages, reasonable working hours, job security, safe working conditions. We have to investing in skills, government, industry, and education institutions. They must collaborate to create targeted skilling programs that align with the demands of the future economy, driven by AI and technology. There should be inclusive growth. It must be transparent and adaptive governance. To my understanding, this adaptive governance is the key of the whole system, which is missing today. And that is required for making the labor laws more effective, more workable, more adaptable to the people. I'm very thankful to give me this opportunity in addressing my views on the subject. Thank you very much once again. Namaskar and Jai Hind.
The last 10 years, what is it that you think has made justice more accessible to the common person, the poor person?
See, it is a fact that during the last 30, 40, 50 years, unfortunately, the system of justice has become pro-rich. The common man is finding difficult day by day to get justice from the courts. There are different reasons for that. Number one, the lack of awareness among the common people. They are not aware of their rights, so it takes a lot of time for them to come to the court. Second is the legal system. With all respect to my senior colleagues and all lawyers everywhere in the country, it has become so rich-oriented that a common man is not able to engage the lawyers of his choice because of the economic restraints. Third is the language problem. See, English is the language in all the courts, High Court, Supreme Court, District Courts also. But a lawyer coming from a common family like a Tamil Nadu, Punjab, Manipur, he finds it difficult to communicate with a lawyer in the absence of his mother tongue being the court language in the High Court, Supreme Court and all that. I'm personally of the view that now time has come where the mother tongue of each lawyer, each citizen should become the court language, not in the trial courts, in the High Court, but in the Supreme Court also, Now there is a provision for translators, everything can be done.
Right.
That will further give a chance to the common man, to a poor man, to get justice as early as possible.
You spoke about judicial activism. There's another phrase that's doing rounds. It's called judicial overreach. We heard that during the deadlines that were set for governors and president to clear bills. But even in the case of SIR or even the stray dogs issue, a lot of people feel that the Supreme Court is acting like a supra-constitutional body. A lot of people have welcomed it. Some people have reservations. What is your view on
You
this?
see, Supreme Court or High Court or any court, they have to decide as per law. Whatever the law, they have to decide. They can't enact the law. Law has to be enacted by the parliament. Now, this Bihar electoral revision, Bihar, all those who are criticizing it, I will tell them, request them humbly, please read the Representation of People Act 1950 and the registration of electoral rules which were framed under that. The complete procedure has been prescribed there. Who will be the ordinary resident? Whose vote can be deleted? Whose vote can be added? What is the remedy available to him? Appeal to the district officer, then the state officer, then the High Court, then the Supreme Court. Without reading the laws, without reading the provisional law, when you start interpreting law, that creates problem. So far as the Supreme Court is concerned, Supreme Court goes by and large with the facts of the case. And let's not forget, all are human beings. In the Indian judicial history, I remember my then Advocate General, Mr. Bhagwant Singh Sandhu, was arguing a case before a full bench in High Court. The Chief Justice said, Mr. Sandhu, you are not right. He said, Lordship, don't say I am not right. He closed his file. He says, law is not static.
Yeah.
Today, because you are a judge, I am a lawyer. Whatever you say will prevail as law. But tomorrow, who knows, your judgment may be overruled by the Supreme Court. And who knows, after 10 years, Supreme Court may overrule its own judgment saying, no, that was not correctly decided. So last chapter of judicial history has not been written, should not be rewritten. It should continue so that there is an evolution of law.
Thank you, Mr. Jain. So justice is as much as in the law books as it is in lived experience. So building credibility and accessibility of our systems is very important. Thank you, Mr. Jain, for speaking to us.
When we speak about constitutional morality, sir, in a sharply polarized political environment, has the definition of constitutional morality and the understanding and the debate around it become so politicized? You say tyranny of the majority. At least the majority in parliament turns around and says, look, this is a political allegation.
Your question is about majoritarianism versus lack of versus the opposite view. Let me start by saying this is not about questioning the majority's right to govern. Democracy is defined as ruled by the majority. Churchill famously said that democracy is the best form of governance amongst all the worst forms which we have. So it is not a good form, but it's the best available form amongst the worst forms. Now, the crux of the point we miss in terms of constitutional morality is that while the rule of the majority is the meaning of democracy, constitutions are created only for the purpose of entrenching a large number of rights untouchable by the majority. Why would you have a constitution if you had majority rule? The whole idea of a constitutional document is when it says part 3, fundamental right to free speech, fundamental right to trade, this, that, and the other, to life and liberty, to religious freedom. These are all anti-majoritarian rights. The very reason our founding fathers spent 3 years in creating them and entrenching them was to protect every citizen, whether or not he is part of the majority. Whether or not he is part of the majority. Otherwise, every one of these rights can be overridden because you have a majority. So therefore they said, first, some rights are necessarily anti-majoritarian. They need protection against majority will. Second, those can also be overridden, but by special majorities, 2/3. Third, there are some rights which even 100% of the legislators cannot change. Why do you have basic structure? I declare tomorrow that this shall not be a republic but a monarchy. I declare today that only blue-eyed babies shall have the vote. Why can't I do it? I have 90% of the vote. A very good real life example, is the NJAC. We don't have consensus or we have a fractured consensus in parliament, not even a statute can be passed because we are fractured. But on the NGAC, there was 99% voting, 100% in the Lok Sabha, and 99.9% only Ram Jethmalani got up and voted against. Why was it struck down? Majoritarianism, no? Why was it struck down? These very people struck it down because they are the guardians of the Constitution who are supposed to uphold what they think. Of course, they can be wrong, but they are entrusted with the job of declaring what they think is against the basic structure, and they found that judicial independence is part of the basic structure and NJAC goes against judicial independence. I'm not debating the judgment. I'm giving an answer about majoritarianism. There is no such thing as majoritarianism simpliciter in a constitutional republic.
Thanks very much. On that note, Mr. Abhishek Manu Singhvi, we leave this conversation here for want of time, but a fascinating conversation both from a legal point of view as well.
This panel brings together experts from legal practice, forensic investigation, consulting, and academia to explore exactly what is happening and what is transforming legal work. My first question is, how do you see AI tools such as predictive analytics or even contract automation transforming the role of practicing lawyers in India?
So in the medical field, we have medicine professionals who provide consultation, then you have surgeons, and you have a whole industry of diagnosticians. So today, nobody dares to give you an opinion without saying, please go and get this battery of tests done. Right. I actually see an evolving trend where there will be a framework where a new career which includes or integrates law and technology will evolve, and we will become increasingly dependent on them for our decisions.
Of course. I'll go to Jayant after that. From a forensic and compliance standpoint, how are AI and advanced data analytics changing the way investigations are conducted?
18 years ago, when I started with forensic technology as a space, we had to literally go to people and ask them why they weren't using technology in their investigations. Cut to 18, 19 years later, I can't do a forensic investigation without the use of technology, right? So that's how evolution happens, and that's how it's going to happen for everyone here in their lifetimes. As far as an investigation itself goes, if I look at transactional data, it is all sitting in digital forms.
Right.
If I look at the evidence trail that gets created through the discovery process, which is through emails or documents, that is largely sitting in digital formats. And of course, over the last couple of years, we've all tried out, tested out, moving away from traditional keyword-based reviews, which is what used to happen, to now using generative AI to be able to summarize a whole set of documents, things that could be done, or that would take us perhaps a year and a half to go through in a large matter, now can be done in a matter of 6 to 8 weeks.
Professor Vinay, what has been the impact of Gen AI, specifically, say, tools like ChatGPT, DeepSeek, to students and the way they absorb curriculum, the way they absorb the classes, the courses that you have?
The technology that we have right now, the AI platforms that we have, will add a lot of ease to the legal profession, because it can do a lot of things that essentially require, a sort of a researching type of a framework. So AI is quite capable of actually digesting a lot of data and putting it in a very cogent way. So therefore, it's quite simple to actually use an AI framework to actually understand the research of a case. And therefore, every lawyer will have to basically equip themselves with these new technologies, because it has a huge utility.
I'll come to Arun Balaji. How in your work on, say, integrity and compliance, how do you see AI creating the biggest opportunities and risks for legal as well as the regulatory systems?
So I think the opportunities part has been covered well. I will only add a couple of them which is not covered. People feel that this is going to take away jobs, but that's not the case, because these are going to create jobs, because this is doing what was never done before.
Right.
So often companies will have thousands of contracts, never read, never looked for obligations. So it's only creating jobs. So people should not have that fear that AI is going to take away jobs. So the opportunity itself is going to get created for more employment. Second opportunity is the speed at which we can do, like Jayant was mentioning on how you can sift documents, which was taken months, can be done in about weeks. And more importantly, like how Sapna is saying, also bring in predictive part of it to say how can you predict and reduce the focus in which otherwise we would have spent years together before we could go to a court or even go to an arbitration. So when all these opportunities are there, the risk is like how Cyril was mentioning a little while ago on bias. I call it, in our parlance, we call it as an operator bias, because the prompt I'm giving and what I'm asking is what it will give back. So typical word to look out is an operator bias. So the more I am biased into what I need to know, that's what it is going to tell me.
Thank you very much to each one of you for taking the time out and joining us today. And for the students, as you heard, read, read, and read. On that note, thank you.